Well, good morning and hello, and welcome to another Sunday morning coffee with Dr. Childress. Today, I want to talk about the New York Blue Ribbon Commission report on forensic custody evaluations. Now, from my perspective, I think this is a very clear and important independent review of forensic custody evaluations and the that practice of forensic custody evaluations needs to end. It needs to be eliminated from the family courts, and we need to return to court involved clinical psychology and assessment, diagnosis, and treatment. And the psychologists need to get out of the custody business. So we'll talk about that and what the New York Blue Ribbon Commission found. An important piece of the discussion is this discussion from a couple of the commissioners from the Blue Ribbon Commission who discussed their findings. And I think this is a very valuable video discussion for all professionals in the family courts to watch, especially the legal professionals, because one of my deep concerns about this is that the legal professionals are getting extremely bad professional consultation advice from a small group of forensic psychologists who have personal motivations, conflicts of interest relative to their careers, what they're doing, their financial interests in promoting a particular type of assessment and intervention, which is an absolute failure, these forensic custody evaluations. And so there's prominent problems with the professional psychology input into the family courts. And I would strongly recommend that all legal professionals, attorneys, family law attorneys, judges, everyone watch this discussion of the Blue Ribbon Commission report on forensic custody evaluations. So, what did they find? Let's discuss a little bit about the Blue Ribbon Commission. So, this is from the conclusions. Ultimately, the commission members agree that some New York judges order forensic evaluations too frequently and often place undue reliance upon them. Judges order forensic evaluations to provide relevant information regarding the best interests of the child or children, and some go far beyond an assessment of whether either party has a mental health condition that has affected their parental behavior. And I want to take this piece or this introduction sentence to highlight that what the courts are actually looking for is whether either party has a mental health condition that's affecting their parental behavior. And that would be like child abuse or a delusional thought disorder or a factitious disorder imposed on another. Those type of psychological issues is the domain of professional psychology. Custody is the domain of the courts. And so the clinical psychologists or the psychologists need to return, the doctors need to return to their domain and coordinate their work with the court. In their analysis, evaluators may rely on principles and methodologies of dubious validity. In some cases, because of a lack of evidence or the inability of parties to pay for expensive challenges of an evaluation, defective reports can thus escape meaningful scrutiny and are often accepted by the court with potentially disastrous consequences for the parents and the children. So, potentially disastrous consequences, defective reports, dubious validity. These are awful professional pieces of work. And right now in the family courts, I am that meaningful scrutiny. That's my role in the family courts. I'm a clinical psychologist. I don't decide on custody. I've never done a custody. I would never do a custody evaluation. I think they're methodologically extraordinarily problematic, and it's just wrong. I just wouldn't do it. And so I'm a clinical psychologist, assessment, diagnosis, and treatment, and I'm trying to get the court appropriate information from clinical psychology, and it's being blocked by the forensic psychologists who are only providing the court with their forensic custody evaluations and their input regarding custody and they are blocking other clinical interventions from reaching the court. And so that's a particularly difficult situation. But I'm serving a second opinion, so I'm the meaningful scrutiny on these defective reports that are coming out of the forensic psychologists. So the commission, by an 11-9 margin, the majority of commission members favor elimination of forensic custody evaluations entirely, arguing that these reports are biased and harmful to children and lack scientific or legal value. At worst, evaluations can be dangerous, particularly in situations of domestic violence or child abuse. That's a pretty scathing review of these forensic custody evaluations. They lack scientific and legal value. That is correct. They are dangerous and harmful to children. That is correct. Now, wait, I want that to sink in. The forensic psychologists are doing something that is harmful to children. Let that settle in. It has no scientific or legal value. These are the psychologists who are doing this. It has no scientific or legal value, and it is harmful to children. Okay, it's not me saying this. This is an independent review. You can see right there, harmful to children, lack scientific or legal value, dangerous, and they favor the elimination of forensic custody evaluations entirely. That means all the forensic custody evaluators need to be gone from the court system. Let that sink in. If we are eliminating all forensic custody evaluations, then we are eliminating all forensic custody evaluators, which means all forensic custody evaluators, particularly the leadership, is now in a conflict of interest position. It is incumbent upon the professionals in the family courts, the legal professionals and the qualified, capable mental health professionals who are here. It is incumbent upon the professionals to acknowledge the failure of forensic custody evaluations, and we need to stop that process. We need to stop that abomination that's harmful to children. Harmful to children. The psychologists are harming children. We need to stop that and return to a clinical diagnostic assessment of what the pathology is in the family, treat it and fix it. But the forensic psychologists in the leadership positions are disabling the mental health system response to the pathology in the family courts for their own financial self-interest and career status interests, because if we eliminate this abomination of forensic custody evaluations, then we eliminate the psychologists who have been harming children for 40 years, who have created this thing that lacks scientific or legal value, and who are in a position now where they are in a conflict of interest. If they acknowledge their failure to allow us to properly respond to the child abuse, then they admit they failed for 40 years and they admit they're incompetent in what they're doing. They're negligent that they need to go because they're custody evaluators and not clinical psychologists that we need over here. So there's a transition that needs to occur in the family courts relative to the professional services received out of psychology. And there are psychologists who are blocking that for their own financial and career status interests. These members reached the conclusion that the practice is beyond reform and that no amount of training for the courts, forensic evaluators, or other court personnel will successfully fix the bias, inequity, and conflict of interest issues that exist within the system. And so those are just statements drawn out from the New York Blue Ribbon Commission. I would strongly recommend you watch the video of the two commissioners discussing their findings and discussing the abomination that is forensic custody evaluations and the reason they need to be entirely eliminated, along with the custody evaluators who have been doing them. So let's find out a little bit more about these custody evaluations. So forensic custody evaluations, this is important for everybody to understand. Forensic custody evaluations were an experiment on children that were created by a few people. They didn't exist before the 1980s. And they're leaving healthcare, they're leaving clinical diagnosis and treatment. So it's a new made up approach to assessment, these forensic custody evaluations that have no history. Look back in the 1930s, 1920s, 1880s, no history of forensic custody evaluations. There's history of diagnosis of other pathology, doctors, and treatment going back medicine for a long time. No history of forensic custody. They were an experiment. Their experiment failed. As a result of their failed experiment on children and parents, the lives of thousands upon thousands of children and their parents were irrevocably destroyed. That should have never happened. These psychologists should never have been allowed to experiment on children and their parents. There should have been some oversight. There should have been, they should have at least provided the court with the alternative and the parents with the alternative of a clinical diagnostic assessment or their forensic custody evaluations. Take your choice. But they only gave the court and families the one option of their forensic custody experiment because it was financially lucrative to them and built their career on a failed experiment that destroyed the lives of children and parents for decades. We need to stop the practice of forensic custody evaluations and return to clinical psychology, diagnosis, and treatment. And we need to fix the pathology in the family courts. So two of the prominent forensic psychologists who developed this model are Dr. Stahl and Simon. They've written two books or two editions of the same book, Forensic Psychology Consultation in Child Custody Litigation, a handbook for work product review, case preparation, and expert testimony, published by the American Bar Association. So they have literally written the book on how to conduct these forensic custody evaluations that lack scientific and legal value. So this is what the New York Blue Ribbon Commission is reviewing. They say this lacks scientific or legal value. They say this, what they're proposing, is harmful to children. It produces defective reports, and this, what they're proposing, needs to be eliminated entirely from the family courts. So to be clear on what the New York Blue Ribbon Commission is critiquing, it's critiquing the work of Stahl and Simon and the other forensic psychologists. So let's take a look at what they said, Stahl and Simon. So in 2013, they published their first edition, that's Stahl and Simon. And in 2020, just a few years ago, they published their second edition, Simon and Stahl. So in 2013, now remind you, forensic custody evaluations came on the scene in 1980. So 2013 is what, 30 years, 25 years from the start. Okay, so 25 years, 2 decades in, as a formal and organized field, forensic psychology has entered its adolescence, but is far from mature. Let me tell you, healthcare and clinical psychology is mature. Diagnosis and treatment, DSM-5, American Psychiatric Association, our diagnoses, our research. We are mature in healthcare. This is an experiment they're developing off of their own imaginations. They're based in nothing except their imagination, and it's far from mature. Well, then it needs to go, because children's lives hang in the balance of their decision, and their decision has to be accurate. 2020, just a few years ago, as a formal and organized field, forensic psychology has entered its adolescence, but is far from mature. They haven't moved an inch in a decade, and they haven't moved an inch since 1980. They're just doing what they do. This is what the Blue Ribbon Commission critiqued: this negligence, this laziness, this incompetence. It's still in formation. These facts serve to illustrate the reality that as an organized field and as an organized systematic approach to behavioral science, forensic psychology remains in its formative years. This, in 2020, this illustrates the reality that as an organized field and as an organized systematic approach to behavioral sciences, forensic psychology remains in its formative years. These people, these forensic psychologists, are lazy, they are ignorant, they are negligent, they are incompetent, they produce these forensic reports that lack scientific or legal value, are harmful to children, with potentially damaging consequences for children and parents in the family courts. They need to be eliminated. It needs to go. Yet, these forensic psychologists will prevent that from happening, prevent the elimination and what needs to happen, because their own career depends on it. If we get rid of the forensic custody evaluations, then we get rid of the forensic custody evaluators who've been doing them, because that's the only thing they do. They don't know anything about any other pathology or anything. They've just been in the family courts doing their forensic custody evaluations for decades. So if we get rid of those, we get rid of them. But they don't want to leave. And they're in the positions of authority who are advising the court system. So from my perspective as a clinical psychologist on the outside, I'm advising the legal professionals in the court that the advice that you're getting from a small group of psychologists is wrong advice. It's really bad advice that you're getting, and we need to switch that out. From Stahl and Simon, 2013. Despite the clear and convincing argument for the use of a forensic model when conducting child custody evaluations, there are still those who argue that a clinically informed approach to child custody evaluations is appropriate and preferable. We strongly disagree with the clinically informed approach. That's important to understand for these forensic psychologists. They have left the field of healthcare, diagnosis, and treatment, and they've given themselves permission to do something different. We do something different. It's a forensic mindset that's different than the clinical mindset of diagnosis and treatment. Bad, 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 bad. We're doctors. We diagnose and treat. They got off the wrong track when they left the field of being doctors and started to be mini judges deciding on custody. Because forensic psychology is truly a new field, 2013, it's truly a new field. Many child custody evaluators, having been trained only in the clinical tradition, bring to their work what we call a clinical mindset rather than a forensic mindset. Clinical thinking and the clinical mindset are no longer thought to be an appropriate approach to forensic psychological work. While there may be some overlap between forensic and clinical thinking, we view these modalities as distinct. So that is a clearly evident statement that they have left healthcare, they have left the field of clinical psychology, and are doing something different that they call a forensic mindset. What's the conclusion on the forensic mindset? It lacks scientific and legal value. It is harmful to children and produces defective reports that are dangerous. And I want to emphasize again, when the Blue Ribbon Commission says these reports, these forensic custody reports, are harmful to children, that means the psychologists who are conducting these reports are harming children. I'm in the family courts as a clinical psychologist treating the trauma, complex trauma to the parents, the targeted parents, being caused by the forensic custody evaluators who are removing their children in collusion with the abusive parent. My goodness gracious, we have forensic psychologists who are in active collusion with the child abuse, creating trauma, complex trauma, removing kids from a normal range, healthy parent because of the pathology, because they are misdiagnosing the pathology, because they're not competent in the diagnosis of delusional thought disorders, and they don't care. That's really bad. When you have psychologists who are participating in child abuse, who are harming children by fact, Blue Ribbon Commission says these reports are harmful to children. That means the forensic psychologists are harming children. That's really bad for the psychologists to be harming their client child because of their forensic mindset rather than remaining doctors in the healthcare field. So, to return, the New York Blue Ribbon Commission, by an 11-9 margin, a majority of commission members favor elimination of forensic custody evaluations entirely, arguing that these reports are biased and harmful to children and lack scientific or legal value. At worst, evaluations can be dangerous. What these forensic psychologists are doing can be dangerous, particularly in situations of domestic violence and child abuse. So, in my 10 years of practice, I would identify these 6 people as the primary people responsible for the approach of forensic custody evaluations. Robin Deutsch, Matthew Sullivan, Michael Saini, Robert Simon, Philip Stahl, and Leslie Droids. And so again, to remind you that the New York Blue Ribbon Commission, an independent and outside review of forensic custody evaluations, recommended by 11-9 the elimination of what these 6 people do, what these 6 people created, what these 6 people advocate. They say it needs to be eliminated from the family courts, and they are correct. It needs to be eliminated entirely, arguing that these reports are biased. What these psychologists are doing is biased and harmful to children and lacks scientific and legal value. So that's the outcome. That's the grade from an independent outside review of the work product of these 6 psychologists and their followers. Everybody who's been doing what these 6 have decided to do. Make up this new approach with a forensic mindset. And so all 6 of these have developed an approach that is harmful to children. So, you want to know who it is? There it is. So, 3 of these, Robin Deutsch, Matthew Sullivan, and Michael Saini, are associated with the overcoming barriers failure. Now, let me explain this a little bit. These psychologists, forensic psychologists, wanted to mimic what Dorsey Pruder was doing in a 4-day workshop and her success, because she was, and the people were getting referred to her High Road workshop, and they didn't like that. So they said, we can do that. So they got together, this whole group of forensic psychologists got together and gave themselves carte blanche. They could develop anything they wanted, okay? And they developed this 4-day workshop, this overcoming barriers. Complete failure. I watched it happen. I watched it come in. I watched it fail. I watched it leave. Now, the problem with that is I know some specific cases that were potentially going over to the high road where it would have been fixed, but they were diverted into the overcoming barriers where nothing happened. So essentially, the overcoming barriers forensic psychologists prevented the solution for the family, the recovery of the family, by putting in their inert, uh, ineffective treatment that essentially did nothing, which is what their custody evaluations did, which is what their reunification therapy did. So the fact that they developed a 4-day workshop, for one thing, it's getting slammed by everybody. All these 4-day workshops, when you hear that around Caden's Law, that's one of them. Overcoming barriers by the forensic psychologist is one of the 4-day workshops they're talking about as being an absolute failure. And so it was developed by a bunch of psychologists. It was a complete failure. It's now defunct because it was a failure. And this is demonstrated evidence that the leadership of forensic psychology has no idea how to solve the pathology. There's only 2 causes of treatment failure. One is misdiagnosis, and we're treating cancer with insulin. The other is incompetent delivery of the intervention for that diagnosis. Because if your diagnosis is accurate and your treatment is competently delivered for that diagnosis, you're going to fix things. So either it's you've misdiagnosed the pathology, you're treating cancer with insulin, or you're not competent in the delivery of the intervention. So we have overcoming barriers, complete carte blanche to do whatever you want. It failed. Why? Did you misdiagnose the pathology? Yes. Are you incompetent in the delivery of the treatment? Yes. You're both. It would be my argument to them. And I'll debate this anytime with anyone. No problem. Online debate, the role of professional, clinical and forensic psychology. Now, Dr. Simon and Stahl literally wrote the books on forensic custody evaluations and how they conduct one. So it's their failed experiment. And then Leslie Droids is a prominent forensic psychologist who's written many articles in support of this experimental model, and she's cited with a moderate degree by the other forensic psychologists. So those are the 6 leaders at this point who, in my opinion, have substantial conflict of interest issues right now and need to step aside in their leadership positions to allow the field to transform properly away from what they do, forensic custody evaluation. And what they do needs to end. So I'm not sure what they're going to do to earn money or something. They can go work with ADHD or something else, I suppose. So favor elimination entirely. That's the grade for these. That's outside and independent review recommends they are eliminated entirely. So these psychologists need to be removed from leadership positions in professional psychology because of conflict of interest issues and for past failures and incompetence and extraordinarily problematic practice and coming up with solutions and offering solutions to the family court that lack scientific and legal value, that are harmful to children, that are defective reports, and listen to the critique from the commissioners. So these psychologists need to be removed from leadership positions, and these psychologists need to leave court-involved practice for their proven negligence and incompetence. They need to go away. What's happening in the family courts and the needs of the children in the court are far more important than a few individual psychologists who failed, came up with their own experimental, destroy the lives of children, just led everybody into a destructive path for decades. They need to go, and we need to get back on track, and the courts need to get back on track. The legal professionals need to get a handle on what's happening in the courts, and we need to get you good, competent clinical psychological services. If you listen to the commissioners, that's what they're asking for in the end. They're saying, can we get competent mental health services? Yes, you can. As soon as you clear out the select people with names who are disabling the mental health system response to the pathology in the family courts because of their own conflict of interest issues, because that's what they do, forensic custody evaluations, and they are an abomination. So to understand this really clearly, the differential diagnosis for the pathology in the family courts is either the targeted parent is abusing the child in some way thereby creating the child's attachment pathology towards that parent, or the allied parent is psychologically abusing the child by creating a shared or induced persecutory delusion and false factitious attachment pathology in the child for secondary gain. So to understand from a clinical psychology perspective, one way or the other, the diagnosis for the symptoms is child abuse. I just need to know which parent is abusing the child, because the only thing that causes that level of symptoms is child abuse by one parent or the other. That means that every single custody evaluation in the last 40 years should have returned a diagnosis of child abuse one way or the other, because that's the only thing that causes it. But they didn't diagnose stuff. They did something different, the forensic mindset. So I would argue that for the past 40 years, the forensic psychologists with names, those Deutsch, Saini, Sullivan, Stahl, Simon, and all the rest that follow them, okay, have been failing in their duty to protect. And I would argue it's a negligent failure, failure to take proper care, failure to diagnose, failure to boundaries of competence, violations of 2.01 boundaries of competence, 2.04 bases for scientific and professional judgments, 9.01 bases for assessment. Multiple ethical violations, failure in duty to protect, producing dangerous reports, harmful to children for 40 years. They need to go. And these though, are the psychologists currently giving advice to the courts and to the mental health, to the legal professions. That the legal professionals need to be alerted to this. They're problematic psychologists and their consultation they're getting. So from my perspective, as a psychologist looking at the list of the 6 psychologists in the family courts, and I've seen all their vitas. So I have reviewed the vitas of those 6. And based on their education, training, and experience, their vita are Doctors Deutsch, Sullivan, Saini, Simon, Stahl, and Droids competent in the diagnostic assessment of delusional thought disorders when the pathology is a possible delusional thought disorder, in attachment pathology when the pathology is an attachment pathology, factitious disorder imposed on another when the pathology is a factitious attachment pathology imposed on the child, and are they competent in the diagnostic and assessment and treatment of child abuse when the pathology is child abuse. Clinical psychologists, I've looked at their vitas. These are my questions. Okay, you can look at their vitas, and their licensing boards can look at their vitas, and the AFCC and their judges can look at their vitas and answer that question. We can look at their vitas in cross-examination, and they can explain to us in cross-examination where exactly they obtained their background, education, training, and experience in the diagnostic assessment of delusional thought disorders. So, for me, I have mandatory ethical obligations because the ethics code is required. It is mandatory. So that means all those boundaries of competence issues for the forensic psychologists are required, mandatory. My mandatory obligations is when psychologists, believe that there may have been an ethical violation. I believe there may have been an ethical violation by another psychologist, by Doctors Deutsch, Sullivan, Saini, Stahl, Simon, and Droids. Okay, so I believe there's been an ethical violation by another psychologist. They attempt to resolve the issue by bringing it to the attention of the individual if an informal resolution appears appropriate and the intervention does not violate any confidentiality rights that may be involved. I presented to the AFCC in 2018. I've sent letters to a couple of these psychologists expressing my concerns. I've done my informal. I've been in the family courts for a decade. They know who I am. I've sent them materials. They know what's happening. I'm confident that they are informally notified of my concerns regarding their ethical and professional violations. So we then move on to 1.05. If an apparent ethical violation has substantially harmed or is likely to substantially harm, yes, it has substantially harmed. I have the New York Blue Ribbon Commission saying it is harmful to children. Yes, it is substantially harmed. Yes, it will likely continue to substantially harm the children and parents in the family courts. and is not appropriate for informal resolution under 1.04, it's not, or is not resolved properly in the fashion, it wasn't, then psychologists, me, it doesn't say may, it says psychologists take further action. It directs me to take further action appropriate to the situation. What is further action appropriate to the situation? As I look at the situation right now, the forensic psychologists control the licensing boards, they control the APA, they control the AFCC. The legal professionals are floundering because they can't get accurate or appropriate mental health services because they're being blocked from those by the forensic psychologists, and they have no access to outside consultation other than the forensic psychologist. I'll note that Dr. Saini, one of this group who does harmful forensic custody evaluations, is the president-elect of the AFCC. Okay, so next year he's going to be leading the AFCC from overcoming barriers he doesn't even know how to solve it. I would look at his vita. He's not competent in the assessment of delusional thought disorders and factitious disorders and attachment pathology in children or in child abuse. And he's in the president position. And if we eliminate forensic custody evaluations, he's out of a job. And he's in the leadership position for the next year. I say and so the legal professionals are not getting competent mental health services. And so what is the appropriate action, the further action appropriate to the situation for me? This is part of it, is to make the courts, make the parents, make the public aware of the extraordinary problems within professional psychology right now in the family courts, the need to eliminate forensic custody evaluations, and the disabling of the mental health system response by a few forensic psychologists who have their own personal, financial, and career motivations influencing their judgment. So for me, what the APA recommends I consider is such action might include referral to state or national committees on professional ethics, to state licensing boards, or to appropriate institutional authorities. Okay, so there's my marching orders. So while all of you are doing what you're doing, this is what I'm responding to. I believe there may have been ethical violations by other psychologists, individuals with names, and that are harming children in the past, and are substantial harm, and are likely to substantially continue to harm children with their forensic custody evaluations that lack scientific and legal value, and that have been so harshly critiqued from outside and independent review. So what do we do about that? I have duty to protect, I have duty to warn, so I'm warning the parents, I'm warning people out there regarding this practice that is harmful to children by the psychologists, and I'm notifying the court that it should likely seek alternative consultation, and the legal profession alternative consultation from people other than the forensic psychologists who have been providing consultation for the past 40 years. So again, I would strongly recommend that everyone in the legal profession, parents as well, but everyone in the legal profession, watch the discussion of the Blue Ribbon Report from the commissioners to learn just exactly what Drs. Deutsch, Saini, Stahl, Simon, Sullivan, and then the droids and all the rest, and everyone who participates in that financial exploitation of this vulnerable population, see what they do. When they actually looked at what they do, it is extraordinarily bad. So with that, I'm going to wrap up my Sunday coffee this week. And next week, we'll talk about some other aspect of the family court situation until we get solutions for kids, until we can protect the children from the child abuse in the family courts. As soon as we get children protected in the family courts, I'll go do something else. But right now we have active child abuse and active spousal abuse that is not being diagnosed, not being treated by this group who do something different. And they need to be eliminated. The forensic custody evaluations and the evaluators who conduct them need to be eliminated entirely from the family courts. And with that, everybody have a nice weekend. Take care.